Go ahead.
Okay. Yeah, I'm Karen Burns, Karen A. Burns. I was sole practitioner here in Boulder since 1985. I do workers' comp and landlord tenant. I used to work half-time at CU Student Legal Services, representing students in landlord tenant issues. And I was the 2013 instructor for the CBA volunteer attorneys on the landlord tenant issues during the 2013 flood.
All right, and for any of you who don't know me, I'm Brett Landis. I am currently managing attorney for Boulder County Legal Services. We're the local legal aid office for Boulder County. We're part of Colorado Legal Services, so anyone seeing my screen that says CLS Boulder, that's who we are. I also used to work with Legal Aid Services of Oregon for about 6 years, and I've practiced landlord-tenant law both in Colorado and Oregon, covering a range of private landlord-tenant and subsidized housing as well. Currently, since all this craziness started, I've been working as part of a housing retention group through the county, working with community mediation as well on that, to try to figure out how to address some of the unique challenges we're facing right now. And I'm also part of a Colorado Legal Services task force on housing issues during this crisis. So I hope that I am fairly up to date on what's going on, and happy to try to pass off any information that I've gotten through these channels. I thought it would make sense to just kind of go over briefly what we're going to talk about today. If people do have questions, there is the chat box, so feel free to post in there. Really, the big thing that we're going to talk about are the problems created by the current crisis, and the many, many, many challenges that both property owners as well as low-income tenants and regular income tenants who may find themselves with less income than they're used to are going to be facing. Specifically, we're going to go into issues with evictions and talk a little bit about the CARES Act. And then Karen's going to talk a fair amount about some solutions that might arise, and then I'll go over some of the local community resources we have. Karen, anything you want to add on that?
No, I think that's all. We'll go over some general review of eviction law, but also how things are going to change with the COVID pandemic and some resources. Sure.
Okay. So I want to start with just kind of a brief poll, and if you can put your answers in the chat box, just let us know how familiar you are with landlord-tenant law in Colorado. It's kind of a little subset, and I imagine we have some people on the call who it's a regular part of their practice, people who've maybe done a couple of cases, people who maybe think they might remember something from like first year of law school when you took property law, and people who have no idea what we're talking about. It'll just help us know kind of how much overview to give. Cool, and we've got a nice wide range. Cool.
Good.
Always ends up being fun. Well, this is good. We have mostly A through C, so so we're not starting from the very beginning. Awesome. Excellent. All right. Well, so the thing to remember is during this time, as David Bowie said, you can expect changes. So what we tell you today, we hope will continue to be true. But as always, you want to check back in with people to make sure you're getting the most up-to-date information. I know the governor's office has issued a couple of different orders about this. Our local courts have issued a couple of different administrative orders, and it's gonna keep changing. I think we're all in this phase right now where we're doing a lot of change management and coming up with with new solutions and finding new problems every day. So that is the big caveat for this whole CLE. So since I primarily work with tenants, I want to go into some of the tenant problems that we can expect at this time. The big one is going to be non-payment of rent. Right now, we are at a situation where so many people have lost jobs due to this virus. And even people who haven't necessarily lost their job are looking at a decrease in income. I think anyone who's been paying attention to the news, the unemployment rates are just going through the roof. And an organization recently did a study that said about 500,000 people are going to be in danger of losing their housing once this is over due to job loss and income loss. Another issue that seems to be coming up is a lot of people are feeling the need to break their lease or desiring to break their lease. CU, I believe Naropa, other schools have been closing, and that affects where a lot of our students who don't live close to Colorado, what they're wanting to do. Some people may have family that are sick that they need to be caring for elsewhere, and it's creating a big disruption there. And then finally, the third group that we're kind of seeing issues come up with are people whose leases have ended in the middle of a pandemic. A lot of times these people don't want to move because looking for new housing is putting them in more contact with people. The act of actually physically moving is causing a lot of extra exposure. And then we also have a subset where the landlord has been wanting to show the property to prospective new tenants in the middle of a pandemic. So these are just some of the issues that we're seeing crop up. And really what underscores all of these is a great deal of fear. Fear of the future, fear of their health in the future, fear of current health, fear of income. And when people are making decisions out of fear, I always say they're thinking with their lizard brain and not their rational brain. So that's really our role and our job, is to try to help them move from the fear-based decisions to the more rational ones.
Okay. And somehow by default, I became the landlord rep, but I also represent many tenants and have for a year. I actually sent out an email to several of the larger property management companies and landlord representatives with a survey asking them what their experience has been. And I'm not sure if it's because of everyone working at home or they didn't want to close their positions, but I have not heard back from anyone. So I'm going to assume some issues for landlords on their behalf. Okay, first of all, obviously, it's financial burden of mortgage payments. We'll talk later about the possibility of mortgage relief for also property owners. But this, most landlords, even if they're large landlords, will have to keep paying their mortgages. I had one landlord representative put out interesting defense, which was if shelter-in-place orders are here, it's to keep the tenants in the units instead of moving out. So I just throw that out for edification. Somehow, spell check changed this to feds, but we know what it is, it's FEDs. So a suspension of FEDs will run up damages, and this is for both sides. By the time some of these cases will be filed, the amount of past due rent could be $12,000, $13,000, $15,000, $20,000 on some of these larger rentals, and they, frankly, they might get bumped into district court. And finally, we'll talk about this more too, but the courts are going to be overburdened when this finally is reopened, and everyone's going to face that.
Yeah, so one of the big issues that has come up is concerns about people breaking the lease. I think the message that we really want to convey is that the virus itself is not an excuse to break one's lease. Karen, you've had a few more cases involving this, if you want to talk more about.
Sure. I've had a couple of students that actually said they're afraid of catching COVID-19, so they want to leave and go out of state and go home. Frankly, fear of catching a disease is not enough to break a lease. We're talking legal standards, not moral standards. I also had a landlord call just recently, and his tenant is renting a very, very expensive house, and said she lost some money in the stock exchange, so could she stop paying her rent? And so I think maybe losing money in the stock exchange is not enough. So we're talking just basic legal concepts here. I always say there are reasons for breaking a lease, but they might not be offensive to imposition of the lease terms. So.
Yeah, I think one of the groups of people that we are a little concerned about who may have some legal relief would be people with disabilities who are often in high-risk groups. So anyone with chronic, like COPD, other chronic pneumonia, they could potentially have an argument for a reasonable accommodation, depending on the situation. And then I think, Karen, you had the one with the, what I call unorthodox housing situations that happen in Boulder a lot, where some of the formalities may not have been observed.
Right, and, you know, a lot of times there are people that have verbal agreements or live in a ADU, an accessory dwelling, and may or may not have the same agreement or terms on their lease, and, you know, they may fall through the cracks, but there's still issues that have to deal with that. So.
Yeah. So I think the moral on breaking your lease is, you know, do a thoughtful analysis. There may be some relief. More likely, though, if someone just wants to break their lease because they want to break it, that's not going to be a significant enough reason.
Yeah, and just quick, just before, you know, there are a lot of property managers, companies in Boulder that have lease break provisions where they pay a certain fee to get out of the lease. But I would just be cautious and read these leases, because most of them say you pay a certain amount of money, but then you're still liable for all of the lease terms. So if you have a lease breaking issue with it, it might be good to have someone review the lease and the terms before you take action.
So we have the other category of people who are at the end of their lease, and rather than wanting to break it, maybe want to stick around. So refresher back to first-year property law, these are going to be your holdover tenants, is the term I typically use. Many leases will have actual holdover provisions written into them that says what happens when a tenant stays past the end date in that lease. Normally, what you're going to see in most leases is that the tenancy is going to convert to a month-to-month, usually with a little bit of an increase in rent. Depending on how much the landlord really wants that tenant out, it can be higher or lower, depending on when you made your lease. The important thing to remember is to actually kick someone out against their will, though. Even if they're one of those holdovers, the landlord is still going to have to go through the legal process. The notice that the landlord would have to give at that point would be the notice to quit, and following that with an eviction action. So you can't just change the locks at the end of the lease. I think that's probably more obvious to this group than many people, but important to remember, you still need the court system to actually force someone out. I think it's also, again, important to be aware of some of these high-risk people with disabilities and people who might potentially have a reasonable accommodation argument. If you have someone who has chronic respiratory issues or diabetes and they're at the end of their lease, they could ask for an extension as a reasonable accommodation. And again, that gets into some Fair Housing Act provisions. Karen, anything you want to add about holdovers?
Well, I don't want to create a nightmare, but when the new provision was passed last year for the 10-day notice, there's a snag, and frankly, this is a few of us that do also FEDs, and technically, a couple of us went all the way to the court administrator to get this straightened out. At the end of a lease, let's say your lease ends after a year naturally, there is a notice to quit is not required. So yeah. I mean, I don't want to get into details on that, but the actual court explanation of FEDs online is implies that it does need a notice to quit. So that's just a technicality.
Okay. In terms of showings, which has actually come up probably a little more frequently than I expected it to, really from a public health perspective, we're just asking people, please don't. Having a bunch of people from the outside world tromp through a unit or a house that someone has been renting, and all the people actually living there right now have contact with, it seems like a perfect storm for creating more exposure and spreading this virus. Additionally, as far as showings go, the Attorney General's office sent out a letter in response to a complaint on March 31st, indicating that showing real estate for sale is not considered a necessary activity under the stay-at-home order. So that would certainly follow up that, showings for rentals would be in that same category. That while you can still move, you can still do your real estate transactions, there's some indication that the showings, the marketing is not considered essential at this time. The county has actually issued some guidance in that they are encouraging people who are looking at the ends of leases to work with the current tenants and really try to arrange for virtual showings. So much of our life is now digital, and that is going to carry over with real estate showings too. So we have these tools, let's use them to the best of our advantage. So now we're going to move on to probably the meat, the biggest course of this presentation, and probably the one that most people are worried about right now, which is evictions. And I think the moral there is that really at the end of the day, everyone is in a situation right now where they're going to lose, and it's deeply unfortunate. So Karen's going to go ahead and talk about the normal eviction procedure, what that normally looks like.
Sure. This will be, let's say, January 1st, 2020, before everything hit. I'm just going to go real quickly through this. If people haven't done a lot of these, the demand for compliance is now 10 days instead of 3. That's for residential. We're just talking about residential evictions. Notice to quit, again, would be not for a violation of a rent or for a violation of a rule. It would be for, like, the end of a lease or if there's not a written lease. Filing for court, summons and complaints. Service, everyone probably knows that if you post only, you get judgment for only possession and not damages. If you serve personally and posting, you can have a judgment for possession and damage. The return date used to be 7 to 14 days. There is always, as those that come to Friday morning FED court knows, there's always volunteer mediators, and judges encourage us to do those resolutions instead of getting a judgment. Evidentiary hearing, frankly, again, it depends. The day of the return date is just for the issue of possession. Most judges then say there will be a follow-up trial if there's damage to be determined. Writ of restitution, it would be entered if there's a default or if the tenant does not appear, and if sometimes there is discussions as to why rent was not paid and it was not accepted by the judge, so that would be for the writ of restitution for possession only. The case would be dismissed if the tenant files an answer with a valid defense that's accepted that day, or if service is not effected correctly. And again, the writ of restitution is posted by the sheriff within 48 hours. All of these things are going to change as we see.
Yeah. So,
okay. Okay, so, yeah, we're looking at, I polled some landlord attorneys, and I've come up with some ideas of what landlords might be able to do. First of all, we have to understand that, first of all evictions are suspended for now, and there are no civil return dates for landlord-tenant issues for eviction. So one idea, and again, I'm not advocating this, I'm just saying it's a possibility, is to file a money case, meaning just for the rent and not for possession. However, in county court, we do not have any available current return dates. So if you file it in county court for under $15,000, it's going to be, I would imagine, rejected at this point, but eventually, if it's filed, it will have a return date, I would say probably in June. A district court is different because if a money case is filed in district court, it will still require a defendant to file an answer, but there will be no availability of motions, practice, or procedure probably until June or July. So, again, I actually have a landlord right now, I think, filing a district court past due rent case against my clients, and I don't know if it went through, but I will find out soon. And the other issue is, frankly, if you're the landlord, you will not get an order of possession in these money cases. You'll still have to either go back and start over with an FED in June or July, or you'll have to only go for past due rent. So.
yeah. So to expand a little on what Karen was saying about there being no evictions right now, I want to talk a little bit about the differences between normal times and now. So on the left-hand side of the screen, you can see that that's the normal procedure we just went over and what that procedure looks like. So currently during COVID, these initial notices before filing are still allowed. You can still post them on people's doors. That may be something that would change in the immediate future, but there would need to be another big order or big notice going out to the community if that's not going to be allowed. Filing in court. You can still file your summons and complaint in court. I put this in yellow as opposed to green, though, because right now, attorneys can still e-file like they normally would, but pro se parties can only file by email or fax. People are not being allowed into the physical courthouse itself to file handwritten summons and complaints. That's not considered essential, and they really don't want people exposing the staff that's currently working there or handing papers that they've touched that other people have touched. So you can file it in theory by email or fax as a pro se party, or you would have to hire an attorney to e-file it for you. Service can still happen. Posting that service is an option. It's a little unclear whether personal service by the Sheriff's Department would be an option. In theory, I think you can still personally serve people, but again, it's going to be a little iffier with a lot of the restrictions. I imagine a lot of process servers are also kind of being cautious as far as their employees go. And here's really where we get to not just the yellow parts, but the red parts, the nice red stop sign. Return dates are not going to be scheduled until after May 31st. Additionally, the evidentiary hearing is not going to be scheduled until after May 31st. And right now, the writs of restitution are stayed indefinitely. So even people who have already gone through this procedure and had a writ of restitution but hadn't executed that writ yet, their writ is stayed until further notice by the chief judge. And then posting the writ by the sheriff, our sheriff's office is not doing that. That is not a law enforcement priority right now. I will say, so this procedure is specifically for Boulder County. I have talked to other colleagues throughout the state. Certain counties are treating this very differently. I think the 1st Judicial District in Denver is not even accepting filings of evictions, so they would get stopped at this stage. Other judicial districts, particularly out in the Eastern Plains, are actually holding these hearings in that they're doing them telephonically. That's creating a number of other concerns about whether or not tenants are getting notice of the telephonic hearing. But my understanding is most sheriff's departments are not posting writs right now. So just a little bit of warning if you practice outside of Boulder County, this is specific to Boulder County. So check with your local court's administrative orders where you practice. So really the question is, why is there such a big difference? There are a number of different orders. There's a stay-at-home order that Governor Polis issued that was followed by a public health order. Additionally, Boulder County was fairly proactive and issued its own stay-at-home order. And the Colorado Supreme Court issued an administrative order. What followed that administrative order was the 20th Judicial District's administrative orders, basically disseminating the guidance from the Colorado Supreme Court into a number of different things. There is an order for limited operations that went in March 17th. A further clarification on that on March 20th. And then on March 25th, the writs of restitution were stayed indefinitely. And I do see we have a chat question. Get that. And that would involve me being a little more tech savvy, sorry. So Tom is asking, do you have any guidance on whether filing now will place a case in queue ahead of other cases? I do not know, Tom. I would imagine probably the courts are going to treat it the same as they would the domestic relations cases, that things are just going to sit in a pile for a while, but I don't know if that's going to create a queue. We can follow up and ask the bench for further guidance on that and how that's going to be administered. And someone is asking about changes within the city of Boulder. That is true. Certain municipalities have issued their own stay-at-home order. City of Boulder is one as well. I don't know that it's any stricter than the county's order, the stay-at-home order for the county. I haven't looked at that as intensely as I have with the county's order, just because that covers a broader group of people. But I would imagine it would be pretty in line with that. I think when I read it, it was fairly similar. The other thing we really want to remember logistically is there's limited staff at the courthouse right now. They are down to a skeleton crew, which means compared to the normal group of several deputies working at the courthouse, there's one deputy. Our sheriff's department was hit pretty hard and really had to allocate resources where they were most needed. And that being at the jail, doing public safety work. The clerks, normally there are about 50 people working behind the scenes at the courthouse, processing filings, accepting filings, setting up the cases in the e-filing system and in the docket system. Right now, there are only three to five people working at a given time. And they're all the supervisors who have been training the other people to do that work, but it takes 3 to 5 people a lot longer to do things than it takes 50 people. The judicial assistants currently are not working. They're staying at home and don't have access to a lot of their resources they normally would. I think 1 or 2 have been helping out their judges, but even then, without their normal tools, they're not able to do the full scope of their work. And then the judges, I want to emphasize they are working really hard, but there are only going to be 3 at the courthouse at a specific time, and they're rotating that to try to keep it fair and limit exposure. All of them, though, are working very long hours from home, and they're doing so without their regular staff. So when you normally hear back relatively quickly, that's just not a possibility right now. So that's really the most practical reason why we're seeing these limitations. I did include links to the various orders. There's the governor's order, Boulder County's order, Colorado Supreme Court's page, and the 20th Judicial District's. And all of those orders are usually pretty prominent when you click on the links. And I think Kyle is going to send out the slides after this, so you should have access to that. So moving on, beyond just our current local eviction work, we are looking at some federal involvement under the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act. There are several housing provisions within the CARES Act itself. Specifically, the CARES Act issues an eviction moratorium, which tenants' rights attorneys were all very excited about. However, it doesn't apply to everyone. It applies to subsidized housing, low-income tax credit properties, and properties with federally backed mortgages. So basically, if this housing is getting money from the federal government, whether it's through a mortgage or through subsidized housing, HUD grants, and whatnot, it's going to fall under this eviction moratorium. The moratorium is for 120 days. So since it was signed on the 27th of March, the moratorium actually expires June 25th. After the expiration of this, it is going to require another 30 days notice to evict a tenant. In Colorado, I believe someone quoted me the statistic that 40% of single-family homes did have federally backed mortgages. So I think for anyone representing a landlord, it's important to know whether or not that home is federally backed or whether that mortgage is federally backed. The flip side of the eviction moratorium is that for those federally backed mortgages, there is mortgage and foreclosure relief written into the bill as well. So it's not saying if your tenants don't pay, you're going to default on this mortgage. You have your own relief in there as well. So that's a little bit of good news as well. And then the stimulus payments that we've heard a lot about, they can be a source of money potentially for people to pay back rent. Realistically, those checks are going out in stages. So some of the checks will start arriving this month. However, some of them aren't going to start getting to people's pockets until after September of 2020. So I think if someone is counting on that stimulus money to pay back rent, they need to have a really clear understanding with the landlord that may take a while. Yeah, so obviously the current state of things leaves everyone with some significant challenges. Karen, would you?
I think we have another question, which.
Oh, okay.
Yeah, I'd be glad to answer it, or you could too. You see it?
I'm not seeing the question, so I don't. Do you want to? Oh, I I see the question, but I can't see the message.
Oh, okay. What if a
So,
tenant states, yeah, that there are no CU classes?
what was that?
Let's see. What if the tenant states that if there are no CU classes at all, they will not show up? Can a landlord treat it as anticipatory breach and try to re-rent the place? I guess what I'm saying is there's an exception for the CU students that are in the dorms that they were ordered to leave, so they actually are treated differently. But for a private CU student that says, I don't want to stay because I'm either taking classes online or they canceled all my classes, that regardless of the reason they leave, if the regular landlord-tenant eviction requirements are still in place. So even if the tenant breaches the lease by leaving town and going home in the middle of the CU semester, my opinion is eviction still has to be litigated to get possession. So.
All right. So let's get to kind of the challenges that we see.
Okay, again, for the landlords, I've kind of gone through this, but the bottom line is that for both sides, frankly, is that when this moratorium passes or the suspension of FEDs or the cancellation of return dates, whatever happens in the next 60 days, there's going to be an onslaught of landlord-tenant cases, and for both sides.
Yeah, so really right now you can't process either the evictions or the money cases. For the tenant side, you know, all of the various relief that's gone through, your rent is going to continue to accrue. None of this says you don't have to pay your rent. It just says they can't evict you right now for not paying your rent. Similarly, landlords are still going to have mortgages and bills due. I think one of the concerning things for tenants is that cure periods are not addressed in any of the laws or orders that have been issued. So we don't know if you still have a right to make up the difference in back rent. And yeah, as Karen was saying, once courts resume processing eviction, there will be a tsunami of cases and not enough attorneys to handle them. And similarly, on the tenant side, once courts resume processing evictions, there will be a tsunami of cases and not enough attorneys to handle them. So I think anyone who has any experience in this is going to be in pretty high demand in this summer, June, July, when these cases are actually getting heard. So I think it's important to know that there are some solutions, and since we're all kind of in the same difficult boat, we're going to need to work together.
Yeah, and you know, I'm always an advocate, regardless of what side I'm on, is to work out some sort of resolution outside of court, some sort of compromise. I understand that landlords need their rent, but if tenants actually are not able to pay the rent, I think some sort of option of waiving late fees, establishing a repayment plan that's reasonable, or possibly reduce rent or suspend rent for a time period, again, combined with maybe a repayment plan for after the pandemic is over. Something that was brought up for mortgages, and it's also for rent, is if this goes on for 90 days and the tenant is 90 days past due on rent, it's very few of them are going to be able to pay a lump sum of that amount when the case finally goes to court in June or July. So I think it's actually of everyone's benefit to work something out, some amortization or some repayment plan that somebody can actually afford.
So fortunately, we do live in a community where there are a lot of resources and really a lot of efforts through the various county and city governments to help us minimize what's going on and to make that flood of cases that's likely to happen this summer a lot more manageable for the courts and for all of us. So I have a whole list of resources here, which again will be available later with the slides. Community mediation is really, I think, the most proactive step people can take right now. If you're having trouble having that conversation, really communicating with your tenant or calling community mediation are going to be good options. Normally, community mediation, there's a City of Boulder program and a City of Longmont program. Both of those programs have been expanded to cover the entire county. So in Netherland Ward, in Lafayette, Erie, Louisville, Lyons, one of those two offices is going to be available to assist people with these mediations. Additionally, the county has some limited rental assistance available. They are going to be focusing on the most vulnerable people, but they also have a really great resources page set up. It's this website, and that has links to other sources of rental assistance, such as Sister Carmen, the Hour Center, Emergency Family Assistance, and those might be resources that people will have to draw on. Additionally, the county is going to have a housing helpline. They're not going to be widely advertising it. It's mostly going to be through referrals, but everyone who's on this call, I think, would be able to refer someone there for assistance. And I didn't include this specifically because I just found out about it. But the county also has a personal finance program, which if people are in the boat where they're needing to talk to their mortgage company, even if it's not a federally backed mortgage, to try to get some relief because their tenant isn't paying rent, that personal finance program is something that can assist people with that and kind of give them an idea of what to expect. And I know they're ramping up some actions. And for the landlords that are businesses, there are some small business association loans available to help people get through this time. I think the more resources people can come up with, the more options they will have available to kind of weather this storm, because getting new tenants in, if your old tenants can't pay, is going to be really tricky right now. If things do come to litigation, our office is very available for people. We are still doing intakes. We are a free service for people who meet our income limits and asset limits, and they can apply by phone or on our website. And the district attorney's office, which does not directly represent people, but the Community Protection Division, can look at things if people are engaged in predatory practices. Additionally, their website, the Community Protection Division, did a great number of one-page fact sheets on COVID-19. So there's one on landlord-tenant issues, there's one on domestic violence, and then the one that I think is always really interesting for people to know is the one that they did on potential scams and consumer frauds that are out there. So really informative stuff, always going to be a good resource for people to look at. And then finally, our host today, the Boulder County Bar Association, is providing a lot of resources for people right now. Laura and Kyle with the Availability of Legal Services Committee got a virtual clinic up and running, so people can call in and schedule time for 20 to 30 minute consultations with a volunteer attorney. Anyone on this call who has not signed up for that is welcome to do so and really help provide a good service to the community. The Bar Association regularly does referrals to private attorneys like Karen. And if anyone for some reason does not know the Bar Association's phone number, it is right there. Laura and Kyle are obviously still working mostly from home, so we're lucky that they are still continuing their work.
Yeah, and quick, Brett, things are changing literally by the minute. So I was mentioning to Brett, Texas State website as well, because Governor Polis mentioned something on the news last night about a $3 million rent relief fund. I don't know who it's with or what it's for, but the way I look at it, look at state and federal as well as county resources, and there's a possibility of help on those levels as well. So.
Yeah, and I think the rent relief is getting funneled to the different counties directly. So it's getting authorized by the state and then sent to the different counties to administer, sort of like the Colorado Health Plan and other public benefits that the counties normally run, temporary aid to needy families, that sort of thing. But yeah, yes, as we said at the very beginning, things are changing quickly, and we can expect that they'll continue to change. So we will actually, this is the time when we're actually moving on to questions. So we already have one. Do tenants have leases expiring during the stay-at-home order have any legal options other than to move? Tenant is able to pay rent, but landlord is not wanting to negotiate or extend renew lease. What is your opinion of the enforceability of holdover clauses with excessive charges? Ooh, that is an outrageous holdover clause. $200 a day. So probably my first recommendation in that circumstance would be to call community mediation and see if one of the mediators can help that landlord come down and become a little more reasonable in what they're expecting. You know, I think you could force them to go through the eviction process and really possibly incur excessive damages later on. But really the point of the mediation would be to really limit those damages for both sides.
And I didn't see the message, but just routinely there are lease provisions that I think may not be enforceable. And so I highly recommend people that have a holdover clause like that of $200 a day or $500 a day of late fees to have possibly an attorney review that lease, because it may be in the contract, but it may not be something that's allowable if it goes forward. So.
Yeah. Any other questions?
And Brett, this is Kyle. I just wanted to point out to people, if anyone wants to unmute themselves to ask a question, you can just hit the space bar on your computer, and that will temporarily unmute you while you ask your question, if you have one. So.
All right, well, if we don't have any questions, I just want to say thank you to everyone for coming to this, and please remember all this information. I'm happy to be a resource if people do have questions that crop up later on. And again, if you are interested in helping, please sign up for the free virtual clinic, because I know these questions are going to come up a lot. Oh, and we do have more questions. We'll be emailing these slides out. So I think Kyle has been emailing these slides out after each CLE in this series.
Yep, I will send the, I'll send the slides out along with the CLE form for today to everyone who attended.
Okay, great. And just again, if anybody on the group has a question after this, feel free to give me a call too. And also, I think today is one of the virtual free legal clinics, so we're available for that if tenants or landlords need to call in. So.
All right. Well, everybody stay safe and healthy, and have a good rest of your day.
And thank you to Brett and Karen again for agreeing to participate and present today. And thank you for everyone for joining us. So have a great day.
Great. Thank you very much. Thanks for setting it up, Kyle.
Of course. Thank you. Bye, everyone.
Thank you.
Bye-bye.
Bye.